Could I request Pawan to mute because there's an echo when he speaks? So to Shri Pawan Singh Tomar ji, Shri A.C. Singh ji, to the Secretary of the Committee, Sarika Singhal, and to all the wonderful ladies and gentlemen, chartered accountants, non-chartered accountants in the audience. Here's a very, very hearty good afternoon to all of you, and welcome to yet another series of the Manthan, which is hosted by the Corporate Laws and Corporate Governance Committee of ICAI. Manthan, as you know, means to shake or to stir, and the word owes its origin possibly to the Samudra Manthan, where the divine nectar was finally unearthed and Lakshmi was brought out of the ocean. So Manthan basically is an act of stirring that brings in new ideas, new thoughts, new dimensions, new approaches, new cautions as well. So if I were to speak of Manthans, then this particular Manthan, which is about shaking and stirring, should clearly classify to be the mother of all Manthans. And why do I say this? Because there's been a recent change in the PMLA Act, the Prevention of Money Laundering Act, in fact, 2 changes, which have cast a larger role on the fraternity of practicing professionals, namely chartered accountants, cost accountants, and company secretaries, to come into the ambit of the PMLA Act. Now, what does this mean for us? Should I be scared? As a practicing professional, I am one. Should I not be scared? How does it impact me? Can a casual random act that I do in the course of my business or profession, the course of my profession, be held against me? Is there a mens rea that I need to understand? To know the Lakshman Rekha of what you can do, what you cannot do, how do I implement safeguards? I think there are many, many questions running in our minds, and I think I've got a tremendous amount of WhatsApps and a tremendous amount of calls saying, Priya, this is completely unfair. And of course, people very jocularly remark, they say, one is the fact that the CAs have been included seems a bit unfair. The second that is also said is the fact that a significant profession, which is one of lawyers, has got omitted from this notification. Of course, there are no answers to all of this. And sometimes when one goes back to understand why these things happened, various newspapers in their editorials have commented on why these changes have possibly come in. Some people say this is because of a large number of entities which have been incorporated accidentally or negligently by practicing professionals. We had one case where 1,500 shell companies got incorporated in a single place. People attribute various reasons to this aspect of why this came. So in this context, we thought it's important to talk about it. And what best way to learn about something than to actually discuss this? And given that there are many, many, many questions, we felt it's more appropriate to have a panel discussion rather than a standalone webinar where somebody speaks, etc. And we'd be very happy to take your questions that you could put on the link, and Sarika would be sending it to me and I would kind of take it. Sarika, you can start pasting the questions in chat as well. So I'll, in one shot, please. It would disturb the speaker. So that's where we are today. And I, at this opportunity, would like to again put my hands together for a virtual applause to Shri Pawan Singh Tomar ji and Shri A.C. Singh ji for having kindly consented to be part of this session. In fact, we did reach out to them initially, and they were very, very happy to do it, and we're very thankful to you for being here. Shri Pawan Singh Tomar did his MA in Economics from the Jivaji University, Gwalior. He's an IRS officer. He joined the Indian Revenue Services Income Tax in 1986, and he has served as the Principal Commissioner at Karnal, Panchkula, and Delhi. So he's an officer of obviously tremendous standing. He's also worked in the investigation wing, Delhi, for a long period, which possibly makes him eminently suited for this lecture today here. He was known for unearthing the bogus agricultural income racket and also for conducting an inquiry on the accommodation entry providing entities and operators, which is a fairly substantially large problem in India. I've myself done some work on shell companies, and I know what these companies mean in terms of destroying the economic fabric of a country. These companies get created in, 1,000 companies in one address with very little paid up share capital, huge share premiums. Shareholders just disappear after some time, the directors disappear after some time, and a significant amount of money is layered, placed, and laundered. So very nice to know that he's been sort of part of this project, and I'm sure we'll call him for another webinar to acquire greater insights on how best we as a profession can protect ourselves. He's also worked as the zonal director NCB in Gujarat for 5 years. He's also a renowned author. And most importantly, we're very thankful to him. He's an independent director on the ICAI Registered Valuer Organization, which is an entity which has been created by ICAI under the aegis of the IBBI, the IBC, which required us to create a registered valuer organization for the professionals of registered valuers, a new creation in this country after the Companies Act 2013 came in. Also take this opportunity to introduce Shri A.C. Singh. Shri A.C. Singh has been the head of legal division for the Directorate of Enforcement, the DEA, handling cases pertaining to PMLA 2002 and the FEMA 1999, and he's presently a practicing advocate. So ladies and gentlemen, could I please request you to put your hands together for these very, very senior gentlemen who've taken this time off to be here with us today. So thank you, sir. And before we actually launch into the panel, the questions and the answers, and I did a bit of reading myself, went through many articles, went through the changes, and Sarika and I have managed to put together a set of questions. But before we actually launch into the questions themselves, I thought it would be appropriate to seek the indulgence of Shri Tomar to actually introduce us to this act for about 15-20 minutes. So it's over to Shri Pawan Singh Tomarji for his introduction to the PMLA, and thereafter the session will continue. Thank you, sir. So you have to unmute.
Good evening, everyone. I hope I am audible. Okay. As you told that first I will try to introduce the subject in the next 15-20 minutes. PMLA is, everybody knows about PMLA. There are so much news day to day in the newspapers. In the page one, first of all, we see the PMLA news every day. Court orders, PMLA news. This term, everybody is curious, how is this term money laundering came into existence? This money laundering term probably came into existence in 1930s in America. At that time, mafia was very much active in New York and other places in America. So they wanted to convert their ill-gotten money as white money. So at that time, there were public washing machines and laundry. So at public places, these laundromats were kept. So they purchased most of these laundromats in New York and other areas, and they used to count the cash, and ultimately after a day in the evening said that we have earned that much cash from these activities. That's how this term probably originated. And it is a rough estimate that around 2.5 to 5% of the total GDP transactions are mainly by money laundering transactions only. That is a rough estimate. Money laundering, there are basically 3 steps. First is placement. The large cash is divided into small parts. So it is kept out of the bank monitoring system. So suppose monitoring limit is 50,000, so it is broken into 49,000 or smaller bits. Then the next is layering. Layering, everybody knows that money is kept out of the origin. So just it is lost, the audit trail is lost. So it is kept to other account, then to other account, then into the other places it is transferred. So that is known as layering. Everybody knows about layering. Then the third concept is integration. When the first two parts are over, then the money comes back to the original person or to the original place, and it is being used as a legitimate money in the business. So these are the three basic concepts of money laundering. There were some international conventions, how this PMLA Act came into picture. The first was Basel Statement of Principles in 1989. Then this reporting mechanism for banks, KYC was recommended, Know Your Client, in 1989. Then the next came G7 Summit in 1989 and FATF, Financial Action Task Force, which we all read in newspapers nowadays, FATF. They also do the periodical inspections, which ASA Singh will also share about the mechanism with you later. So FATF recommended in the 1989 some basic 40 recommendations were there from their side. These are the foundation, these are the basic recommendations on which most of the countries adopted their anti-money laundering acts. So these basic recommendations are the touchstone or the basic recommendations. Then how is in India, it is, came into picture, this enforcement directorate. First, there was the exchange control to conjure foreign exchange in 1939, around the Second World War. Then in 1947, this FARA came into the picture. Everybody knows about FARA. Then in 2000, FEMA replaced FARA. And from this PMLA 2002 came into force from 1st July 2005. So that is how it all developed in India. Enforcement Directorate is the only department which is responsible for implementation of PMLA 2002. Only they can investigate the money laundering operations, money laundering investigation activities. No other department, including the police department, is authorized to investigate this money laundering part. Enforcement Directorate is head office is in Delhi. It is headed by a director. Director is known as Director Enforcement Directorate. He's a additional secretary rank officer, and generally he is appointed before he attains the age of superannuation, before 60 years of age. And his initial term is fixed term for 2 years, and then his term can be extended up to 5 years, and or maximum age is 65 years, whichever is earlier, 5 years or 65 years. Then there is one director FIU, Financial Intelligence Unit. He is the officer of the rank of Joint Secretary to Government of India, and he is posted. Only serving officers are posted there as the Director FIU. The Director FIU collects the information, and sends and receives the information from the reporting entities and send it across to the different agencies for taking appropriate action. In Enforcement Directorate, there are other officers like special directors are there, and then additional directors are there, joint directors are there, deputy directors, assistant directors, and AO and EOs are the other officers. Most of the senior officers are working in Enforcement Directorate on deputation, and most of the officers are working from IRS, Indian Revenue Service. Either they are from income tax side or they are from Central Excise and Customs side. There are officers from police also, but mostly from income tax and Central Excise Customs. They are working there on deputation for a fixed tenure of 4 years to 5 years usually. I will come to the definition. Like persons definition is same like in the Income Tax Act, so I will not elaborate it much. Then the one important definition is proceeds of crime. It is one of the most important definition for PMLA, just for learning the PMLA. Proceeds of crime, it is defined in section 21U of the PMLA Act 2002. It says it means any property derived, obtained, etc., by any person. Property derived by any person as a result of criminal activity, and criminal activity, which criminal activity? Criminal activity relating to a scheduled offense. So not to every offense, like there are many offenses, like there are many crimes. There are, betting in IPL is also a crime, and there are so many other crimes, day-to-day crimes. But only those crimes which are scheduled offenses, which are listed in a schedule in the PMLA 2002. Only those offenses, only if those crimes are committed, so that is the criminal activity of a scheduled offense. And if some proceeds of crime, if some property is derived or generated, only then it will term as a proceeds of crime. So again, I am repeating, any property derived by any person as a result of criminal activity related to a scheduled offense, or the value of any such property. Sometimes that property is converted. Suppose cash is a person receives cash as a bribe, so it may become a proceed of crime. Then he purchases a property. He purchases a property. Then the property will become the value of that proceeds of crime or value of that property. Am I speaking too fast? I mean, or is it okay?
Sir, it is
No, sir, it's perfect. It's
Yeah.
perfect, sir. Maybe
Okay,
slightly, just a slightly slower is okay, but this is also fine, sir.
Okay, thank you. I will slow down. Then the third component is, suppose the property is taken outside the country, then the equivalent value of the property either in abroad, in that country, or in India, that can also be treated as a proceeds of crime. So mainly proceed of crime means any property derived from a criminal activity related to a scheduled offense. That is the proceeds of crime. I mean, it is the basic, touchstone basic crux of the PMLA. Sometimes we confuse, with the other. It's suppose there is a unaccounted cash is found by the police. Sometimes we are confused, and sometimes we think that it is a PMLA case. It is a money laundering case. So every such thing is not covered in PMLA. It may be, Income Tax Act or the other agencies might act, whether it is a theft case, whether it is unaccounted money. So the other agencies will act on unaccounted money transaction. If it is a legitimately earned, or maybe somebody has concealed his income, it may be that money, but it may not be illegal money. Only if it is proved that it has come through some criminal activity related to a scheduled offense. Income tax concealment or income tax theft, is not a scheduled offense. Income tax ka chori scheduled offense nahi hai. In Income Tax Act, only that one act is there, Black Money Imposition Act 2015. In that section 51 of that section, unaccounted or undeclared bank account or assets in a foreign country. If that complaint is filed under that act, then yes, PMLA will come into picture, money laundering will come into picture. Otherwise, income tax concealment or GST concealment, such type of thing, or unaccounted cash found at a place, these are not PMLA or money laundering offenses. Then there is one basic clarification. These are the scheduled offense. There are two things. One is the scheduled offense, criminal act, which lead to money laundering activity. Once a scheduled offense is registered by police or CBI or some other agency, like some murder is committed. Murder is a scheduled offense, section 302 of IPC. So once a scheduled offense is committed, if it is committed for revenge purpose and there is no generation of proceeds of money, there is no, income is generated. Suppose it is committed for revenge, then there is no money involved, then there won't be any money laundering activity involved in, or money laundering operations or money laundering investigation will not be there. But suppose one Supari killing is there, murder is committed, for charging, after charging 50 lakhs of rupees, then 50 lakhs rupees will become proceeds of crime. So there are the scheduled offense. Once the scheduled offense is registered by police or CBI or some other enforcement agency, then after that ED comes into picture, and on that basis of that FIR, they register their ECIR. ED registers their ECIR, that is their internal document enforcement case information report. So they register their ECIR, then they, one IU is appointed, one assistant director generally, and then he starts conducting the investigation from money laundering angle. Money laundering angle investigation is started by ED. Once they register their own ECIR. Suppose a person who is being tried is being prosecuted for a scheduled offense like murder. Suppose ultimately he is absolved by the court, or it is not proved, offense is not proved, or there is a quashing or acquittal or discharge or honorable acquittal by the court, special court. Then if it results into acquittal or honorable acquittal or quashing, then there will not be any further investigation for money laundering activities. So money laundering investigation is also dependent to some extent on the success of their case, scheduled offense case in the court of law, in the special. That is the basic difference. Property definition is the general definition. I need not elaborate. Property of every description, whether tangible, intangible, movable, immovable, is covered into property. Then I told you about the scheduled offense. It is there in the section 21Y in the definition of 2(1)(y) of the PMLA Act. Scheduled offense, there are three type of Part A, Part B, and Part C are there. Most of the offenses are nowadays in Part A, like IPC offenses, NDPS offenses, drugs offenses, Prevention of Corruption Act, Customs Act, and other acts. I mean, SEBI, Passport Act, Vagera, Companies Act, Section 447 for fraud, etc. All these offenses are in Part A of the schedule in the PMLA. Then in Part B, only Customs Act, Section 132. Only Section 132 is there for forced document or undeclared forced documents are produced. Then that is Section 132. And for that, monetary limit of ₹1 crore is also there nowadays. For other offenses, there is no monetary limit or there is no threshold. Whether it is ₹1 or 100 crore, I mean, the offense is the same. For this, in the Part B, there is this Custom Act, I mean, Section 132. For that, monetary limit of 1 crore and more is there. Then Part C, the same. Part A offenses are there in the Part C. Basic difference is, these offenses have cross-border implications. Otherwise, they are the same offenses like listed in Part A. And other than that, black money and imposition of tax 2015, Section 51, as I told you, about the unaccounted asset or undeclared bank account in a foreign country, that is there. These are the Part A, Part B, and Part C. So there are so many offenses nowadays as scheduled offense in PMLA 2002. Then there is a special code. Special code is being designated by the central government in consultation with the Chief Justice of the respective high courts. Generally, the existing sessions code are being designated as a special code. And generally, these are the CBI courts, where scheduled offenses are also tried. So scheduled offenses as well as the PMLA, this money laundering, this offense, both the type of offenses are tried by the same special court. Then Section 3 is the offense of money laundering. What is the money laundering? And it is the most important section of the PMLA, money laundering. It says whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved. Involved in what activity? In any process or activity, connected with the proceeds of crime. In any process or activity connected with the proceeds of crime. Including like what type of activity, maybe it may be concealment of proceed of crime, possession, acquisition, transfer, use, or projecting or claiming it as untainted property. Some of these activities have been defined, that may be other such activities which are all covered for money laundering. One person who is knowingly is a party. Knowingly means mens rea, which will be A.C. Singh Saab will be talking about the mens rea. So knowingly some act is being committed and he is involved in any process or activity connected with handling the proceeds of crime in any manner, like its concealment, possession, transfer, acquisition, use, enjoying the profits, projecting or claiming it as untainted property. All these things are covered in money laundering. So in Section 3, offense of money laundering is there. Then one important explanation has been inserted by from 1st August 2019, which says same thing, but earlier it was all these activities and projecting or claiming it as untainted property. So there was some confusion whether some handling of proceeds of crime is necessary as well as projecting the same as untainted property. Both these activities should be simultaneously be there for charging a person for money laundering. So some sort of ambiguity was there. So just to counter that, just to take it, some explanation was inserted from 1st August 2019. It says if any of the activity, one activity or more activity, if one or more, so what or is used in place of and. So it means any of the activity like concealment, possession, or projecting or claiming it as untainted property. So it has taken away that ambiguity. So any of such activity, there may be one activity, there may be more than one activity. A person may project it as untainted property, he may also possess it, or he may simply project it as untainted property. In any one activity or more activity, he will be covered for money laundering offense. Then the second explanation is it is a continuing activity. If act was committed, suppose 10 years back, 15 years back, but still, we are enjoying the proceeds of crime, like we have purchased the property and we are still living in that house, or we have given it on rent and receiving the rent regularly. So we are still enjoying the proceeds of crime. So that way it is a continuing activity. So I mean this explanation was brought to do away this ambiguity. Earlier, otherwise, it was like because of the end, if some person is having proceeds of crime and another person is projecting it as untainted property, so both will not be covered. Somebody will take the defense. No, I mean one person has done one activity and other person has done other activity. So unless both the activities are simultaneously, so they will not be covered. Just to do away that, I mean this explanation has been brought in and that loophole has been taken away. One term is there, standalone offense. I mean, standalone offense, when ED claims, investigation is not dependent on the outcome of the scheduled offense. I mean, both the offenses are tried simultaneously. I mean, the scheduled offense is also tried like for murder. I mean, trial is there in the special court, and for money laundering offense, the trial is there in the same court. So ED is of the view that our money laundering investigation is money laundering offense is a stand-alone offense. It is not dependent on the outcome of the other offense. So that is their viewpoint. But at the same time, Supreme Court in a recent case, 27 July 2022, in Vijay Madan Lal Chaudhary has clarified that once the scheduled offense goes like the acquittal or honorable, quashing of the case is there, then money laundering offense will not stand on its own. I mean, this has also to be stopped. So there is a little, confusion on that aspect also. Then the element of mens rea, has to be there for charging a person for money laundering under Section 3. And for money laundering, in Section 4, there is 3 to 7 years of rigorous imprisonment if one person is convicted. Then the prison term will be rigorous imprisonment for 3 years to 7 years for them, and plus fine outs. But mens rea is necessary to prove, for charging a person. It is a state of mind, culpable state of mind. Whether I can speak for 5 more minutes, I believe.
Yes, sir. Please go ahead, sir. Please go ahead. Even 5-10 minutes is also fine, sir.
Thank you. Then the Section 5 attachment of a property. As CA, we are mostly concerned with money. This investigation and this attachment of properties and then confiscation of properties. Generally, there are two types of deterrence. One is attachment and confiscation of the ill-gotten property. That is the first one deterrent, and the other deterrent is the criminality of the act. That is for conviction. A person is charged in a court of law, and the 3 to 7 years imprisonment is meted out. So for attachment, under Section 5, attachment of a property, proceeds of crime is made. It says when the officer, so-and-so officer, has reason to believe. In income tax also we know about the reason to believe, and reason to believe has to be recorded in writing, and on the basis, reason to believe has to be on the basis of some material in the possession of the officer. Reason to believe cannot be based on a presumption. It has to be based on some material on his possession, in his possession, and one has to be reason to believe like that any person is in possession of the proceeds of crime, that any person is in possession of the proceeds of crime, and such proceeds of crime are likely to be concealed, transferred, or dealt in such a manner as it will result in frustrating any proceedings relating to confiscation of that property. So two things are necessary. That belief is necessary. Belief has to be recorded in writing that any person is in possession of proceeds of crime, and such proceeds of crime are likely to be dealt in such a manner, like transfer or dealt with in such a manner as it may result in frustrating any proceedings relating to confiscation of such ill-gotten property. So once such belief is there, then that officer, this power is available to deputy director and above, then that officer, he will pass an order under Section 5(1) and will attach the proceed of crime or will attach the property, provisionally attachment of property, that will be effective for next 180 days. He will pass the order under Section 5(1). There are two provisos. First proviso says that once there is a charge sheet for a scheduled offense, then he may act under this, which I have just shared with you. Then the property is likely to be transferred, dealt in such a manner which may frustrate the proceedings. Then he can take action if the scheduled offense charge sheet has already been filed, then he may take action under the first proviso. Then there were some offenses, there was a time gap. Suppose scheduled offense charge sheet is filed after a couple of years or 5 years. By that time, the ill-gotten property is transferred or dealt in such a manner that it is no longer available with that accused. So counter that, the second proviso came into existence, which says that notwithstanding anything contained in the first proviso, any property of any person can be attached under this section if the officer of deputy director and above, if he is of the opinion, if he has reason to believe, reason to be recorded in writing on the basis of material in his possession, that if such property involved in money laundering, if such property involved, I'm emphasizing the word immediately. I mean, if it says that if I do not attach this property immediately, then this non-attachment of the property is likely to frustrate any proceedings under this act. So this second proviso gives wider powers to the officer, even if there is no scheduled offense has been registered or no scheduled offense charge sheet is there, even then one can attach the property of any person. Any property of any person can be attached. And if the officer thinks it has been generated because of the money laundering thing, I mean, it is a proceeds of crime as per reasons to believe in recorded in writing on the basis of material in his possession. But the main emphasis is it is immediate action is necessary, and he has to justify the immediate action. That unless he attach the property immediately, the non-attachment of the property is likely to frustrate the confiscation proceedings. So this is the second proviso. So this is treated like civil proceedings. Even a person is not accused in the scheduled offense, even his property can be attached under the second proviso. After attaching the property, one has to send, the regions as well as the relied upon material to the adjudicating authority. And within 30 days, he has to file the statement of fact or the complaint to the adjudicating authority requesting for retention of that provisionally attached property. Then adjudicating authority acts under section 8 of PMLA. For attaching a property, no opportunity of hearing is required, though generally, they issue the notice, they ask about the source of income also, but nobody can claim, no one can claim or go to the court that notice was not given to me or opportunity of hearing was not provided to me. They can simply attach the proceeds of crime or the property under section 5(1) for 6 months. Even scheduled offense has not occurred, even then they can, even notice has not been issued, even then they can attach the property. But for initiating the prosecution, but for filing a complaint or charge sheet in the court, pre-registration of scheduled offense is necessary. Unless the scheduled offense has been registered by some other agency, till then, for PMLA, we cannot, file the complaint or the charge sheet in the special court. Then I will take 2-3 minutes more. Then the section 8 is there for adjudication. For adjudication, once these things are reported to the adjudicating authority, then under section 8(1), after receiving the complaint under section 5(5) from the officer provisionally attaching the property, that there is a prima facie case, then if he is satisfied that there is a prima facie case, then he will issue the notice under section 8(1). This adjudicating authority will issue the notice under section 8(1), asking the person, from your possession, your such and such property has been provisionally attached as a money laundering as proceeds of crime. What you have to say in the manner, what you have to say in the matter, and what is your source of, how did you purchase this property? What were your sources for purchasing this property? Whether these are genuine sources or some other evidence or some other information or particulars on which you want to rely in your support, and to show cause why this property or all the properties should not be treated for money laundering activity as properties involved in money laundering, and why the same should not be confiscated by the central government. So first, adjudicating authority himself satisfies himself. Then if he is satisfied, then he issues a notice under section 8(1), and he allows at least 30 days time to the opposite party for explaining his sources of income and for submitting evidence that this is a legitimate property. So he has to furnish the evidence before the adjudicating authority, and that opportunity is provided by the adjudicating authority. If there are more than one owners, then joint owners are there, then notice is given to every owner. If there is properties held on behalf of some other person, then the notice is given to the beneficial owner also. And if somebody else claims that I also have interest in that property, then that person also submit his claim before the adjudicating authority for adjudication. Then adjudicating authority considers the reply and also hears the aggrieved person, and also hears the side of the enforcement directorate, also hears their officer, and taking into account all relevant material placed on record, then they come on to a conclusion, or they record a finding under section 8.2, whether that property is involved, attached, is involved in money laundering. So they record a finding under section 8.2. Then if they record a finding that property is involved in money laundering, then under section 8.3, then they pass an order confirming the order of the provisional attachment. And if they are of the opinion that the property is not involved in money laundering, then the property may be released. So if they are under section 8.2, they record the finding that the property is involved in money laundering, then under section 8.3, they will confirm that provisional attachment order. And after that, this attachment will continue. How long this attachment will continue? This attachment will continue for the next 365 days. So 365 days will be allowed to the ED for investigating the matter and filing the charge sheet also. So unless within next 365 days charge sheet or the complaint is filed by the ED, then otherwise the property will be released after 365 days. If the ED is able to file the charge sheet within the next 365 days, and the property in whose name the property is there, he is also named as an accused there, only then the property will then after that it will continue to be attached unless it is decided by the special court. So that time is allowed to them. And if the special court when it delivers the judgment, suppose it holds that the property is involved in a money laundering, then under section 8.5 it will order for confiscation of the property. And if the court is of the view that this property is not involved in money laundering, then under 8.6, section 8.6, then this order will be given for releasing the property. So this is the role of the adjudicating authority. Once the adjudicating authority passes an order under section 8.3 confirming the provisional attachment, then under section 8.4, the enforcement directorate is authorized to take the possession of that property. So the word used is shall, so they should take the possession of that property. But there was again confusion on this section 8.4 whether they should take the possession of the property or they should not take the possession of the property. Then recently the Honorable Apex Court in its judgment dated 27 July in the case of Vijay Madan Lal Chaudhary has specified that it is not necessary. It is not necessary to take the possession of the property. Only in rare of the rarest cases, the enforcement directorate should take possession of that property. Otherwise, sometimes suppose ultimate power of ordering confiscation last is there with the special court. Suppose the special court finally holds that that property was not involved into the money laundering, then they will order the release of that property. So considering that provision, recently the Honorable Apex Court has clarified that this provision of taking possession under section 8.4 should not be used by the enforcement directorate. They should wait for the conclusion of the trial and the decision of the Honorable Special Court on that issue. Then there is one case law of J. Shekhar. It was decided by the Honorable Delhi High Court in the year 2018. It says that at every stage, reasons have to be recorded by the officer, deputy director who orders the attachment under section 5.1. He has to record the reasons in writing, and the relied upon material has to be there. Then adjudicating authority also has to satisfy himself and record the reasons, and has to record the reasons in writing. And adjudicating authority has to give these copy of reasons as well as the relied upon documents, copy of these documents relied upon material to the aggrieved party. If this, they do not supply or they do not furnish the copy of reasons as well as the relied upon document or material to the aggrieved party, then the proceeding will be treated as vitiated. So recording of reasons is necessary, and they should provide it to the opposite party also. There are so many things, but I think you must be waiting for your questions. So Mr. A.C. Singh will be there to answer your questions. Thank you everyone for listening patiently. Thank you very much.
Thank you very much, sir. So now it's actually over to the questions. So Sarika, are there any questions which have come in? You can put them together on the chat.
Ma'am, I've put in the chat 2 questions.
Yeah. So thank you very much, Singh sir. So this reporting entity definition was introduced in 2013, sir. Whereas the inclusion, where it said there is a designated profession, why did it take the country 10 years to add chartered accountant here, sir? I mean, chartered accountants, company secretaries. What do you think is the immediate reason why possibly this amendment came in now? Is it because of the FATF coming in, the review?
Yes, I understood your question. First of all, I would like to draw your kind attention. We'll have to go in the background before replying your question. The background is this anti-money laundering law. It was UN Charter, which has directed all the member countries to enact anti-money laundering law. Thereafter, UN set up an administrative body which is known as FATF, Financial Action Task Force, for 2 purposes. A, to supervise and oversee whether the country has enacted anti-money laundering law. B, how far such law is effective. I give you example of Pakistan. They have anti-money laundering law, but their effectiveness is 0. That is why they were put under grey list. Secondly, so far as the definition of money laundering is concerned, if you look at section 3, it's a very long definition, and that too in continuous tense. You will not come across any definition under any existing law which is prevalent in this country to have this kind of definition at all. In this regard, you will have to go back to Palermo Convention. You can open Google, you type out the word Palermo Convention, and under Article 6 of the Palermo Convention, the UN has broadly given the main ingredients of the offense of money laundering and directed all member countries to adopt as per their domestic law. Keeping in view of the components with domestic law, they can adopt. Secondly, if you happen to look at the main object of that, which says that an act to prevent money laundering by confiscating the properties involved in money laundering and incidental there. So the main thrust of the act is to prevent money laundering. How the money laundering will be prevented? My senior, Mr. Tomar, has already pointed out that when a scheduled offense has been committed, thereafter ED comes into picture. So then basically ED does the role of secondary investigating agency, not primary. Then everybody will raise the query that then how did the framers of this law have given the title to this act as Prevention of Money Laundering Act? So ED is not preventive agency. That's what I want to emphasize. Preventive agency is Director FIU, Director Financial Intelligence Unit. Under this act, 2 directors have been contemplated. One is Director Enforcement, who has been assigned the powers to search, seizure, freezing, attachment, arrest, and then filing of criminal prosecution. Whereas Director FIU, from section 11 to 15, he enjoys the exclusive powers. It is exclusive the domain as well as jurisdiction of Director FIU. ED has no role to that. Now, I come back to your query because, as I have pointed out, that this act was enacted through UN Charter. My learned senior colleague has already pointed out about the FATF. With regard to that, I would like to draw your kind attention. He has already quoted about 40 recommendations. I just want to supplement thereafter. Initially, it was 40 recommendations. Later on, 9 more recommendations were added in that. Under recommendation number 23, if you go to Google, you will get all these things. Under recommendation 23, FATF has issued the guideline where they say that all the member countries, they should bring all the professionals within the parameter of reporting entity. With regard to that, these professionals, because India is going to be reviewed in this year, in the fag end of this year by FATF. That is why 23rd recommendation was to be inserted. That is why these professional company secretaries, CAs, ICWA accountants and all, they were included. Here you will also, you can raise the query that why not lawyers have been included in that. With regard to that, I would like to draw your kind attention. Kindly have a look of section 126 of Indian Evidence Act, 1872. What does it say? It says that whatever communication takes place between client and his lawyer, that shall be treated as privileged communication. Even court cannot compel a lawyer to disclose what your client has told you. So that was under section 126. Lawyers were already enjoying that protection. Whereas, I am sorry to say, CAs, they are through statute, Society Registration Act. Nonetheless, they have not been able to include their name within section 126. So therefore, any communication by the client to his chartered accountant shall never be treated as privileged communication, unlike communication of a client with his chartered accountant, because that is under section 126. That is, I was surprised there is one question which has been found, that why lawyers have not been included. I give you an example because I have worked with as a governmental expert under UNODC.
So there is a lull in the presentation.
Some countries. Pardon?
Sir, your bandwidth, there is a slight lull, sir. I mean, so yeah, it's better now, sir. You can speak. Sarika, was it okay for you?
Ma'am, a bit disturbance in between sometimes. Yeah.
That's okay, sir. So now we can go to the next question. So we've used this term money laundering.
Let me conclude it. So because of 23rd recommendation, it was necessary on the part of Government of India to bring all these professionals within the ambit of reporting it. So many CAs, they are worried that they have become now more prone to PMLA ED investigation. I just say reporting entity, they are supposed to report to Director FIU. If they come across any suspicious transaction, like banks, if they any transaction take place where 10 lakh and above cash transaction, then they will have to report to FIU. In the event they don't report, they omit. In the capacity of Deputy Legal Advisor ED, I have come across where the Nationalized Bank, they omit it. What will be the end result? The director, FIU, will hold an inquiry, issue so-called notice, and impose penalty under Section 13 of PMLA. That is a fine 30 under Section 13. That order is appealable under Section 26, subsection 1 of PMLA. That can be challenged before PMLA tribunal. Then second appeal can be filed before High Court. And of course, by way of SLP, you can approach the Supreme Court. So it is not so. I just, at this platform, I want to make it very loud and clear that because they have been made a reporting entity, they are become prone to ED investigation. It is wrong. I take you to Section 3. My senior colleague has already pointed out, because it starts with the word whosoever directly or indirectly attempts to indulge or actually involved, process, blah, 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 and projecting or tainting untainted property or claiming it untainted. Here I take a pause because this section, if any lawyer comes within 4 walls of Section 3, supposing he is a lawyer, but he is involved in money laundering. If chartered accountant, he is involved in money laundering, he will be caught, he will be prosecuted by enforcement directorate. In the capacity of legal advisor, I have prosecuted so many chartered accountants and all. Despite being at that point of time, they were not made as a reporting entity. So reporting entity is for the sake of, it is in pursuit of KYC, know your customer, CDD, customer due diligence. So that is why they have put a condition on them to report. And they have enumerated, if you read carefully, the 3rd May, 9th May notification of government, that clearly manifestly shows. So it is not so that they have been put in the as a reporting entity, they have become more prone to PMLA. ED has no role to play in that. I want to make it very clear. ED has no role to play.
Sure, sir. So thank you very much, sir. So if I were to just summarize, this is a fallout of the FATF. That's point number 1. Point number 2, there are very specific references to direct involvement, indirect involvement, and reporting. So whatever threats that existed earlier, always existed, and there were instances. Third is what we like to hear the most, is that as a reporting entity, it's only a failure of reporting provided that there is not an involvement or a mens rea involved, which is contestable in higher courts right up to the SLP in a Supreme Court. Sir, in this context, I would like to move to the next question, sir. We've been repeatedly using the term money laundering. And in fact, I'll come back to this question later. From a chartered accountant perspective, let's say I am not directly or indirectly involved at that stage, but I am a reporting entity. Now, as a reporting entity, there are the safeguards that are prescribed in the book here. No problem. Which is essentially the KYC and the CDD that you spoke about. Know your customer, due diligence, Aadhaar, passport. I find who are you, and then I agree to do something for you. Now, beyond this, given that we've seen the there has also been a huge change in perceptions, sir, in the audit fraternity, the way enforcements have been happening, etc. If as a chartered accountant, I want to safeguard myself absolutely, not only from the letter of the law, but the spirit of the law, how do I ensure that? So we can come up, so suppose my client is entering into a transaction to buy something, and I find that he's buying at guideline value. I don't know if there is a cash transaction involved or not. Could I have a problem there? What would be your general safeguards? Of course, the institute will come with safeguards, sir. We will issue formats of engagement letters, formats of representation letters, which clearly say the client will declare in so many words that I'm not doing anything which is offensive under PMLA. What will be your view? And I'm talking about the highest standard here, sir. I want to ensure that I will not, whether in letter or spirit, get into a problem. What would be your advice?
Yes. Madam, first of all, I would like to draw your kind attention for replying again your query. It is necessary to go into the background. The Prevention of Money Laundering Act, as per scheme propounded under this act, there are two ways to nail a money launderer. One way is to attach his property, to immobilize him from enjoying such property. The other way around is to launch prosecution if he comes within the four walls of Section 3 definition. Right? Section 3 definition. Now, your query is that what precautions, what steps are required to be taken. I give you an example. Most of the time, like recently, I have come across that most of the chartered accountants, they they deposit the free fee, the GST tax through their escrow account and all. Most important thing is that all the professionals, they must keep in mind that they are dealing with their clients. The client is not their family member at all. They should maintain due distance from their client. Now take the example. In most of the cases, I found that the chartered accountant, he is the CA of one company, and he himself opened another shell company, and he himself or his wife has become the director. So if you are deliberately putting your neck in the noose, you cannot be safe. The most important and the fundamental rule is that you must put a thin line with that as a professional, what you are required to do. And because you have to give professional. The lawyers, I give an example, those lawyers, so many lawyers were caught. They said they become intermediaries. If you remember the NCB case of Bombay, one lawyer was caught. He remained inside the jail. Even he was quit by ED also. So we must understand in literal sense that the scope of law, ambit and scope of law is different, and so far as criminality is concerned. So as far as reporting entity is concerned, it is only enabled to imposition of fine and none else. There is no criminality involved in it. So the most important thing is the CAs, the CS, the ICWA, they will have to draw a line that thus far and no further. If they stick to it, they shall never feel any difficulty. The moment you cross the limit.
I'd like to supplement Mr. Singh here. You were talking about purchasing a property and some cash component might be there. How will you know whether cash component is there? First of all, you have to see.
I'm only imagining it, sir. So it is.
Yeah, just sorry. First of all, you have to know about the scheduled offense. Simply, if cash component is there, it will not be covered as scheduled offense. First of all, it might be income tax ka chori hoga, income tax act will take care of that, but it may not be a scheduled offense, number one. But suppose for purchasing the property, I mean, you must be knowing the funds or the bank account of your client. how the money is coming, whether it is coming from a shell company from Calcutta, whether it is coming from some dubious account, whether it is coming from some criminal's account, whether the purchaser or whether the seller is from a dubious background, might be a criminal, then you have to be a little alert and you have to report such transactions. So that may be a little difference and precaution you may always take about the background, about the check, how the funds, how the source of the funds are there. So these precautions can be taken. Otherwise, simply by cash component, I mean, it may not be a scheduled offense. I mean, there may not be a PMLA case for that. Thank you.
Because it talks about creation, acquisition of asset, etc. So I just thought it important. So we've been repeatedly using the term money laundering now. There is obviously placement, layering, and integration. Can you please explain to us what these three terms mean? Also, from a context of as a practicing chartered accountant, how I need to identify whether any of this is happening.
Madam, I would like to draw your kind attention. My senior colleague, Mr. Tomar, has already narrated in detail about placement, layering, integration. Here, I would also like to emphasize these are three ways which have been evolved by Westerners. I can give you an example. In one CED case, there was neither placement nor layering, straight away integration. Because pardon?
How does that happen, sir?
It happened. I will take you to Madhu Koda government, which remained in power from 2005 to 2008. In that case, what happened that the entire rural electrification program, whatever grant was given by central government to state government, entire money at one go, he called one Hawala dealer and he transmitted the whole money to Liberia, and from that money, mines were purchased. So there was neither
Placement
nor layering, straight away integration. So these are three ways, and most of the time my ED people, they write it is a part of layering, it is a part of layering. It is not like that. Secondly, I would like also to draw your kind attention. Mr. Tomar has already pointed out about Section 5, subsection 2 of PMLA, that any property of any person can be attached. Second proviso to subsection 1 of Section 5. Any property of any person can be attached if non-attachment would frustrate further proceeding of confiscation. If you read closely, you will find that the law, what does it contemplate? There is no lacuna in enacting the law. The lacuna is implementation of law. Law contemplates that in the predicate offense, in the scheduled offense, when charge sheet has been filed, thereafter ED should attach the property. Because after the filing of charge sheet, qua scheduled offense, proceeds of crime will surface. Proceeds of crime will be crystallized, supposing it is being investigated by CBI. There is a fraud committed by the accused person to the extent of 400 crore. They have been able to show that yes, 100 crore went to Mr. X. So therefore, legislature has put certain safeguards, like after filing of charge sheet, they have used the word proceed of crime as defined under Section 2(1)(u). But in second proviso, which is very initial stage of investigation, instead of using the word proceed of crime, they have used, legislature has used the word property involved in money laundering, which means that property which is going to be attached must have direct nexus with the commission of an offense. Supposing he has defrauded 1 crore from the bank, Same money he put it in his bank account, and from bank account he withdrew and purchased a immovable property. Then you can always say that this immovable property has direct link with the property involved in money laundering. But what is going on? These are thin differences. They have been deliberately made by legislature to prevent misuse of the act. But every time, second proviso, because I tell you, the scheme of the act, which has been propounded under the act, it says that there must be always an underlying scheduled offense. If there is no underlying scheduled offense, there can't be offense of money laundering. For example, I give you an example. Supposing a person has acquired 100 crore after committing the offenses under Gambling Act. Can ED do anything? Answer is big no, because Gambling Act is not a scheduled offense. As on date, scheduled offenses in all, there are 30 acts covering 160 sections only. If an offense has been committed under that act, then only it is a scheduled offense. And here I also want to draw your kind attention that ED has been empowered to investigate, administer only Prevention of Money Laundering Act. They cannot investigate any other law.
Yes, sir.
Schedule.
So I would have to, we are getting a lot more questions. So if I can request the responses to be slightly shorter. So one of the key questions people are coming back with is, I do only TDS element for, let's say, a client, which is later found to be a PMLA transaction. Am I responsible? Am I accountable as a reporting entity? But you had mentioned it earlier also, the reporting entity is very clear, where he operates on behalf of a client. Here, I'm only filing a TDS portion or an income tax return. Can I be regarded as a reporting entity? Can you please clarify, sir?
That cannot be.
Great, sir. Thank you, sir. The next question.
It is not. No. Unless there are certain specified conditions. If chartered accountant comes within the purview of that, then he will be liable for to work as a reporting entity.
Correct, sir. Can you just encapsulate that 5 again, sir? Just the headings of the 5.
Pardon?
Just the 5 elements, can you please read out again, sir? If you have it with you. Otherwise, it's okay. We can go to the next question.
Yeah.
Now, it also says, let's say I'm part of a transaction. I'm assisting a client or I'm advising a client. So he says, please help me. You be my investment advisor. You help me to structure out the share purchase agreement, all of it. How do I ensure as a CA from where the funds have been obtained? We may not know whether that the person is a criminal or a Hawala dealer or a shell company. So just the KYC. So the client tells me the money has come only from here. From there, if I take charge, is it enough, or am I supposed to go and examine the antecedent of, for example, you look at AIFs, participated notes, etc. In some of these cases, the ultimate beneficial owner is never known. What is my obligation as a chartered accountant assisting a transaction?
Madam, first and foremost, what is the requirement of it? What is expected from a reasonable, prudent man?
Correct.
That is the fundamental. Like, I give you an example. I am a banker. Somebody comes along with a check of, say, 5 lakh rupees. What I am supposed to do, I have to check the signatures. I have to verify the signatures. If I come across if there is no problem in the signature, I will clear that. Nobody will say that you should have third eye to decide it, because reasonable, prudent man. I have worked for 7.5 years as special public prosecutor, Central Bureau of Investigation. I never prosecuted those bank officers where they said that they took due diligence. Despite that, the offense has been committed. Unless you come across that they are privy to crime, you cannot make them liable. Same principle will be followed here also.
You need not become a detective or an investigator. As a prudent person, as a prudent chartered accountant, only limited to those.
Yes, sir. So the next question, sir, is there a limitation period for initiating the provisions and for issuing a notice? How back in the past can the PMLA Act go?
That has been mentioned in the record, that rules relating to retention of record and all.
8 years, sir.
In that a specified period is there.
Okay, sure.
5 years.
So it's not like they can go back 30 years, 20 years, 50 years.
5 years record.
Madam, these
5
days
years.
the bank do not retain the record more than 10 years. After 10 years, they read out. Earlier, it used to be when I was in CBI, 30 years they were supposed to maintain the record.
Yes, sir. Sir, and I'm also very happy to let you know that we have 650 participants in today's session, sir. So,
How much?
650, sir.
Great.
Great.
Yes, sir. And so the next question is, what will happen to the income arising or accruing of a property which is provisionally attached? Can the alleged holder continue to enjoy the benefit without any fetter?
Let me answer. I mean, even if the property is attached, the person can enjoy the benefits even after adjudication also, unless it is confirmed by appellate tribunal also. I mean, but I stand corrected. I mean, Mr. AC Singh will supplement me further. One can enjoy the profits. I mean, there is no. ED will not come and take possession, as I told you earlier also. So one can enjoy the profits till it is confiscated. But however, I will leave the question to Mr. Singh. He will supplement.
Look here. In the very beginning of my replying on your query, I had told that the scheme provides that the money launderer should be immobilized. How he can be immobilized? By taking possession from it. I give you an example. So far as this act is concerned, earlier in India, there were other laws also. Like I give you example, Criminal Law Amendment Ordinance 1944, where there is a similar provision of ad interim injunction qua the properties which have been generated through commission of any scheduled offence. Why this act is so distinct and different from those acts? The distinction was because of the reason that under this act, once properties have been attached, it has been confirmed by adjudicating authority that director or any officer was duty bound to take possession. Recently, in the Vijay Madanlal Chaudhary judgment, they said it is very harsh and the property should remain with them, with the accused person, till it is confiscated. And now it is little bit deviating from the basic scheme of the act, because 8.4 clearly stipulates when the attachment has been confirmed, the director or any officer shall take possession forthwith. They have used the word forthwith. But now that has been liberalized by Honorable Supreme Court in the order. So that has become law of the land. Supreme Court said in such matters where it relates to narco terror, then the property should be taken possession of. In normal cases, it should not be taken possession of. But it is conflicting with the scheme of the act.
Sure, sir. So that we have a very different question here. It says
Yeah.
it's 365 days, not a very inordinately long period for filing a charge sheet. Should it not be faster? He says, can somebody be put to agony for such an extended period? So what are your views and why is no rationalization happening there in terms of a shorter time frame charge sheets?
I tell you, why this 365 days was incorporated? Keeping in view that in most of the money laundering cases, no accused keeps the money which he has, which is proceeds of crime or property involved in money laundering, to retain the property within the four walls of India. They used to send money outside for conducting investigation. If money has been sent outside India, you will have to take refuge of issuance of letter of request under chapter 9, starting from section 57, 55 to 61. Section 57 says that in such situation, a letter of request can be issued by a special court. It will be sent through normal diplomatic bag. And when it goes there and when they take action, then it shall be presumed under the act that such action has been taken in India by Indian law enforcement agency, whereas actually it has been sent outside India. This entire process of change of information, collecting the information, consumes a lot of time, because you have no right to force the other country to clear your LR. They take their own time. So keeping in view of all these scenarios, this 365 days has been carved out under section A3A of PM.
Otherwise, also in some of the cases, there are complex, layering system is involved. There are so many persons involved, so many destinations, so many bank accounts, so much information is there. So that usually take a time. And sometimes the persons also do not cooperate. They do not come straight forward, or even the intermediate or even the bank, it is not readily available. So these things do take a little time. That's why earlier it was 180 days, then it has been increased to 270, then 365 now. Thank you.
Yes, sir. So this is the repeated question that's coming, sir, is this. The words used in section 3 is proceeds of crime, which includes illegal gratification. At the time of filing income tax returns of an SSC, so clearly here, it's only filing of income tax returns of an SSC. The auditor genuinely believes the explanations given by the SSC and uploads the return after taking a letter of representation also from the client. So the client tells me, this is my income, this is my return. There's no illegal gratification, there's nothing. It's all accounted for now and nothing bogus about it. I'm not as an auditor expected to do any investigation, whether even as an auditor or under this. Under this circumstance, he is not asking about a reporting unit entity. He's asking, can the auditor be held responsible at all under the Act? I think a part of your question was answered earlier also, sir. This part of the question, where you said, if you are clear, clean, and you stick to your brief, then there is no problem. But we'd like to hear it from your mouth.
Ma'am, there is, as sir earlier also replied in the requisite detail, that as a prudent person, one has to do the due diligence. Suppose there is a bank account, he must be having a bank account also. In the bank account, sometimes cash deposits might be there, or sometimes frequent, credits and debits are coming and going back. There might be some suspicion because of the nature of the entries in the bank account. So then, you might like to report such transactions, with the reporting as a reporting entity. But otherwise, you need not become an ace investigator or, source of the source. You are not supposed to ask about the source of the source. But as a prudent, chartered accountant, you, as a prima facie, you can see the transactions in his bank account and his profile and his background. At least you know about your client to some extent. Then if you find something suspicious in his bank account or in his profile, then you can report it as a suspicious transaction to the director FI. And Mr. Singh will, if you want something.
Sorry.
Look here, I think that my senior Mr. Kumar has nicely explained this. In the very beginning, I had told that reasonable, prudent man. And it is not true of cash transaction. It says that if chartered accountant is involved in sale purchase of immovable property, involved in securities, and how it involved, there is again a thin line in the capacity of a professional or in his personal capacity. It is same thing that unveiling, क्या कहते हैं वो, कॉर्पोरेट के लिए यूज करते हैं, बेल वो करना, नहीं बेल आउट, corporate week, piercing the corporate week, well, so it is not like that. I think people without understanding the true meaning of reporting ethics, they are creating hue and cry. Recently, I have read in the newspaper that they are asking the finance ministry that why lawyers have been excluded. So, even if lawyers are there, but the only thing is how can they justify in view of Section 126 of Indian Evidence Act, which remains in this country from 1872. What Britishers, Lord Macaulay has given to us, we have not deviated an inch from that. Wearing this black coat and all.
Yes, sir. So the next question, sir,
is that pardon?
Sorry, sir. The next question, is there any threshold value? Only offences above a certain amount will come under PMLA, or there are no thresholds?
Madam,
any minimum amount?
Look here.
So these are the questions which are coming. So
look here.
So
ED has been charged with a duty to investigate the offence of money laundering. They have created through their technical circulars that we will take up the case of 5 crore amount or above. But tomorrow, if a person goes to High Court and High Court direct, even it is a sir has already pointed out that 1 rupee laundering can also be investigated. There is no threat that Part B is there. Section 132, where the threshold is 1 crore.
Sure, sir.
Otherwise, there is no threshold. Any amount of laundering can be investigated.
Sure,
Depending upon the potential of the case. Like that I have given example that is thousands of murder take place. Unless, and in the capacity of legal advisor, I had got registered the case of money laundering in Peterson matter.
Yes.
Where one lady was killed and because there was huge property which was to be transferred, inherited by those persons. So that ED is required to adjudge whether there is potential or not. Like 307, attempt to murder. I had invoked in respect of kidney racket kingpin, Dr. Amit Kumar, who transplanted kidney. There was a threat that anybody could have died because he was not having the adequate degree of medical science. His properties had not only been attached within India, he had purchased the property in Australia. And by virtue of Section 60, we sent LR and they straight away taken possession of that property which was lying in Melbourne or Sydney. I don't remember at this moment. So, and my senior was saying very important thing. the definition of word property. Only two words of that property, the definition of the word property are, according to me, significant, important, which says that wherever located. These two words have given this act extraterritorial jurisdiction. If somebody is holding proceeds of crime outside India, you can issue attachment order here, and those countries will adhere, they will accept, and they will think that it has been issued by their court.
Yes, sir. Somehow, this concept of the FATF and there's more global voice on aspects such as money laundering and combating terrorism. Then there is inter-country cooperation on matters of income tax or even the insolvency code. Now the code is trying to evolve a cross-border framework. I think it's very well established here.
Madam, I would like to draw your attention. In our country, in our legal system, one of the foremost recommendation is that income tax violation should be made as a crime, scheduled offense. In our country, we cannot afford to make income tax violation as a crime. In Western countries, it is a serious crime where 20 years, 30 years imprisonment can be.
Yeah, I know. We see it in the movies also, sir. The feds are after you. We see it in the movies also. The feds are after me. So, yes, sir. Yeah,
so that is the whole problem. They cannot make, because the golden rule is that income tax violation should be made as an offense, and it should be brought in within the purview of scheduled offense or predicate offense. But we cannot afford, because due to illiteracy of the public, and pan wala is also paying income tax, chai wala is also paying income tax. You cannot make them offense and put them behind the bars at all. If you look at UK and US, they have proceeds of crime. If they come across any unaccounted income, immediately they will start running for offense of money laundering. But in India, we cannot, because income tax act is inherently a civil law.
Correct.
Because it is inherently a civil law, even if you, pardon?
We've got a section of unexplained credits, sir. So it cannot become, it's not considered part of this. So I pay my tax and my penalties on it, and I'm done, as you rightly observed. It's an unexplained credit that people feel it should, by in all its fairness, be charged to tax. So that's where we stand. Sir, I have one last question, sir. So you spoke about KYC and CDD. So if you can tell us KYC and DDD, what exactly do I do from a spirit sense? So let's assume I have a new client who comes to me. So today what's been found, sir, at least in one of the cases here, somebody was involved in incorporating 1,500 companies. So the person had happened to certify the company incorporation documents. We have many, many cases such as this. Even if you look at companies in the east of India, there was a public list of about 16,000 companies with PAN numbers that was there running in the public domain, saying these are shell companies. So I happened to have a look at it, and I found 800 companies having one mail ID. So obviously, and sometimes I'm told later on for them to get SIM cards also, it's pretty simple, because if you're a company, then you can get 100 SIM cards, etc., etc. So in Tamil Nadu case also, one of them happened to be a gold Ponzi scheme and people lost money, etc. So let's assume, sir, I'm a chartered accountant. I'm in the normal course of doing business. Some client comes to me and says, okay, I'm going to incorporate 10 companies. So I will not suspect why he's opening 10 companies, because it is the right of any citizen of this country to open 10 companies. What is the safeguard I should take? Not only in the context of PMLA, but so that this company potentially does not become a shell company or a PMLA company. How do I take care, sir? What is the KYC DDD generically?
Yeah, let me explain. KYC, know your customers. I give you an example. Recently, I came across that if you file any writ petition, any 482, any anticipatory bail before Uttarakhand High Court, there is mandatory requirement that the petitioner will have to annex the copy of his Aadhaar card, copy of his PAN card. Same thing, KYC is considered Aadhaar card, PAN card. Number two, in most of the shell companies, the directors are chai wala, pan wala, rickshaw wala,
Drivers.
driver. And if you call them, they will say that one time they had given 10,000 bucks and asked me to put signature. So if you are vigilant, you can always make out such. Because I don't understand that any chartered accountant who has studied for 18 hours per day and then he became chartered accountant and he is so dumb that he would not like to know who is the director of the company, where from company is functional. So these are the, again, the test of reasonable, prudent man.
Yes, sir. So just one last question, sir. It's a special request from somebody called Alama Prabhu. See, Alama Prabhu from Bangalore. He sent me a lot of questions. So this is the last one. If a person involved in money laundering dies, then can the proceedings be continued on his legal heirs?
Legal heir, look here. So far as attachment is concerned, if the person whose properties have been attached and he dies, then because as you know, as per scheme under this act, adjudicating authority has passed the order confirming the attachment order. Against that, an appeal will lie before PMLA tribunal under section 26 subsection 1 of PMLA. Thereafter, second appeal would lie, that too before High Court, where the person concerned resides, carries on business or personally works for gain. And before High Court, the most important thing is the appeal can be filed not only on question of law, but also on question of fact. These are the inbuilt safeguards provided under the Act. Now, supposing a person dies, the accused whose properties have been attached dies, again, he can continue the proceedings by legal representative. He can be substituted under Order 22, Rule 1 and 2 of CPC, Civil Procedure Code, because these proceedings are civil in nature. They can get themselves substituted and continue with the proceedings. And now there is one more thing. If you read section 8, subsection 7, which was incorporated with effect from 15th of February 2013, which says that if accused has become proclaimed accused died, then his properties may be confiscated or otherwise, depending upon evidences which are placed before the special court. A special court will take a view. It is based on the analogy. I give you an example. Supposing a police officer recovers a dead body having multiple wounds on it. It is a case of stabbing. They will immediately register FIR and investigate under section 302 of IP. They prosecuted 3 persons for committing the murder of deceased. All these 3 persons were given benefit of doubt. They were acquitted. But fact remains that a human being was killed. On the same analogy, even if accused died, if the special court is satisfied that it is the properties which have been attached, placed before it through criminal complaints is involved in money laundering, still he can order for confiscation.
Yes, sir.
I would like to add one thing.
Yes.
Role of CAs. So as per section 39 of the PMLA, right of the appellant to take assistance of an authorized representative. An authorized representative has been defined in the explanation there. It is like as per the section 288(2) of the Income Tax Act. Authorized representative has been defined in the Income Tax Act, section 288(2). So the same meaning will be applicable here. And the accountant there means chartered accountant. So chartered accountants are also legally entitled to do practice,
Yes.
I mean, in such adjudicating authority as well as the appellate tribunal. And secondly, it relates to the proceeds of crime, and one has to tell about the source of acquiring the property of the, I mean, the money laundering trail or the audit trail or the operations. So CA are at a better footing to explain, I mean, to submit the defense of such things, I mean, with the adjudicating authority or with the appellate tribunal. So my request is the more and more CA should come and do practice in such forums. And secondly, even in the ED nowadays, as I shared with you, most of the officers are working on deputation from income tax or central excise customs, with which the CAs are mostly familiar with them, and they are quite civil in nature and quite, I mean, responsive also. I mean, the due respect is also there. So, I mean, I will request the CAs also, they are better equipped, I mean, to deal, I mean, these sources of income and the money laundering and this proceeds of crime and this trail and audit trail, all those things. So that I want to add here. Thank you.
So this is the really the last question. So there is no period of limitation which is specified under the PMLA. So we have Mr. Prabhu who's now asking, so you have to refer to section 468 of the Code of Criminal Procedure, which seems to suggest that the maximum period is 3 years. What are your views on this?
No, he is wrong. He had not read section 468 in letter and in spirit. Actually, if you read section 468, you will find that all offences which are punishable up to 6 months, limitation would be 6 months.
Correct,
If
sir.
the
That's what
offence is
I said.
punishable 1 year, here the offence is punishable not less than 3 years, which may extend up to 7 years. So there is no limitation at all.
Okay. So
There
this
is no limitation.
okay.
And
So-
section 65 of PMLA clearly stipulates that all the provisions of Code of Criminal Procedure shall be applicable except they are inconsistent with the provisions of this Act. Section 4, subsection 2 of CRPC also says that all offences, if there is any local or special law, it provides a special procedure of investigation, inquiry, or trial. Then special procedure will be followed and CRPC shall remain equipped. Here, nothing under PMLA from section 1 to 75, there is no limitation clause. So therefore, section 468 shall apply with full force.
Thank you very, very much to both Tomar sir and to A.C. Singh sir. So in terms of just a small wrap up, I think we had a fairly good insight into what this act is all about. What does it mean to be directly or indirectly involved, which I'm sure most CAs are not, and you're not expected to be. 3, there's obviously, all of us want to do our profession, so we don't have the time to do these things. That's the writing on the wall is very clear. 4, I think sir explained very clearly that as a reporting entity, your obligations are limited. And so is the offense or so is the punishment, which is easily contestable. And of course, you have to prove that somebody has been negligent, etc., etc. So I think the final takeaway is that it's not so bad after all for the CA fraternity. And I'm sure just as we weather most storms, we'll weather this is one. Sorry. And I'm sure in the institute, we are also working on it. We'll come up with some very, very good guidance and safeguards, both in terms of engagement letters, representation letters, and actually in the course of these engagements, which are listed in the reporting entity clauses, we'll try and come up with as good a guidance as possible on how we safeguard ourselves. But having said that, what's the best protection? The best protection is great ethical conduct. So just stay true to our professional ethics, which is to be at the cutting edge of trust and integrity, and then it's fine. See, and one thing again is worthy of importance is that I don't think there should be a knee-jerk reaction to get very scared. primarily because you look at the number of PMLA cases that have happened in this country, and number of cases where chartered accountants have got convicted must be minusculously small. So nobody really goes and picks a chartered accountant in these matters. So I think that protection and ultimately, I believe in one thing: all the good work that we do doesn't go unnoticed. I'm sure when somebody is inquiring a chartered accountant, as Sir said, he says, well, even when I inquired a banker, I really didn't find reason to prosecute a banker because he had possibly done his job right. So with these few words, thank you very, very much once again, but do look forward to our future Manthan series. We'll go back to board oversight, which is the theme that we were running. And I'd like to just read out a small message in terms of the vote of thanks. So very often it's the chairman or the vice chairman who does the vote of thanks, but here we have a reader, a viewer to this program, Mr. Prabhu from Bangalore, who sent it. So I thought I should read it out. It's a highly useful program conducted by the Corporate Laws Committee at the right time, educating the members about the gravity of the provisions, especially in the background of the recent amendments. The members profusely thank, and I have amended it here, the dynamic action of the committee for conducting this most useful event. Our heartfelt gratitude to the speakers for sharing their wisdom with all of us and educating us. And thank you so much for the compliments, Alama Prabhuji. We hope to see you more in the future as well. And if only I had a link, we would have shared it with him to deliver this vote of thanks himself. Maybe next time we'll do it. So once again, thank you very, very much, sir, and we hope to stay in touch.
Thank you.
Thank you. And a huge round of applause and thanks to Sarika Singhal as well, who does these things meticulously. It's not easy. So thanks, Sarika. Thank you so much.
Yes.
Thank you, sir.
Thank you,
Thank
sir.
you, ma'am.
Thank you.
Bye.